to Ms. Coates, and you'll give me an opening statement, Ms. Coates, and see where that lands us.
Yes, Your Honor. Mr. Purser is asking for a reset, Your Honor. He is okay with November 7th at 8:30 being the date. Mr. Purser actually has a meeting at 11:15 with his employers. And so I don't know how long that's going to take, but he's asking for a reset. And right now, this is a confirmation of arrears and modification, Your Honor. The issue is that Mr. Purser is going to be asking Your Honor for about $57,305 in direct pay credit. That's at issue. Miss Yana Honovitska is not in agreement to that, and so that's what the main issue at this time is. She's not in agreement to a reset. Again, I'm not sure how long his meeting will take, but that's he's asking for a continuance, Your Honor.
Let me see. When were they served, Ms. Coates? Is this their first time here? Not really.
I believe this is our second setting, Your Honor.
Okay.
And he was served or appeared April 25th, and she was served July 11th of this year.
Okay, and the form of the direct pay credits that will be attempted to be proven up, is it in writing? Is it something that needs to be screen shared? Is it all testimony? What are we doing?
It is screen sharing, Your Honor. I believe it's bank statements.
Bank statements?
The first one is about 19 pages. And
it's over a period of time, obviously?
Yes. This goes all the way back. Well, he should have been making payments in 2019, Your Honor, but instead he was making them directly to her. So then the second document is 58 pages.
So that is compiled to like what? All the bank statements over a period of 6 years or something like that?
Correct, Your Honor. So from 2019 and until now, so there's I guess 2 banks and then a Zelle transactions.
Buckle up, guys. Today we are going to witness a hearing that starts as a procedural skirmish, but quickly exposes bigger problems. The judge opens with scheduling options while Mr. Pusser asks a continuance for a white meeting and flags bank records and Zelle trails he claimed show direct pay credit. The bench immediately questions whether 77 pages can be fairly reviewed on Zoom, sparking a fight over access to evidence and fairness. This procedural opening sets a tense tone.
Is Ms. Tanevitskaya will not be able to see any of the screen share, so I'm gonna have to talk and identify each one, and we have to make sure she knows what we're seeing and discussing, since she's on the phone.
Yes,
that's a rhetorical question, but
I'm not entirely sure why I'm not entirely sure why she doesn't want to give credit, but that's the issue, the credit.
Okay, we're not talking about any of that, the substance yet, Ms. Tanevitskaya, and you'll get your turn in just a minute. I'm just finding out from the state what's at issue. Okay, anything else in the way of an opening statement, Ms. Coates?
No, Your Honor.
Then the state's going to call you as witnesses one at a time, and she gets to decide who goes first. The person who's not testifying, please remain quiet unless you have a valid legal objection. You're going to get your full turn to talk when it's your turn to testify. So just hang in there with me, and I'll hear from both of you one at a time without interruptions. Ms. Coates.
Mr. Purser, can you hear me? I'm sorry if I'm not pronouncing your last name correct.
You're good. That's correct, ma'am.
You are asking for a continuance because you have a work meeting that starts at 11:15. Is that correct?
Yes, ma'am. If you think we could move quickly, I'm not opposed to moving through this. I was just a little bit surprised how long it took. I think her main objection is she doesn't want to give me credit for it because I didn't pay it to you. So this may go on a while because there's a lot of documentation.
Are you at the office where you have to have the meeting, or do you need to leave?
I'd have to leave here, but I'd like to proceed.
But I'm hearing there's 77 pages, Mr. Purser, of stuff we have to look at, or I had
1,100 pages, and I pulled it down to just the transactions. How this basically started is we divorced during COVID. So the banks, you guys were closed to direct the payments, and so we would go to the bank initially, and I would take out $1,250 on the 3rd and just hand it to her. Over a period of time, when Zelle became a possibility, I started using Zelle. So what I did is I worked in reverse from today back towards that time, because the Zelle transactions were the most documentable. So when I got to like 68,000 in Zelle transactions, that was exceeding my obligation. I just stopped there.
The judge dives into the mechanics. 77 pages of bank statements, multiple accounts, and a Zelle trail spanning years. Mr. Pusser insists he paid directly during COVID and then via Zelle, claiming documented overpayments and a trail of transactions to substantiate credits. The bench grows skeptical about remote review and whether witnesses can meaningfully assess the evidence on screen, signaling an inevitable push for in-person resolution. Procedural fairness becomes the central concern.
Okay, I'm not even sure this thing should be on Zoom, especially if Ms. Tanavskaya is on the phone today. I don't see getting through a hearing with 77 pages of documentation anytime quick.
And ma'am, I'm completely willing to just, even though I've overpaid, I'm good with just, let's call it even and move forward. I have no doubt she needs the money. And a modification is a certainty. I mean, the two that I had with me are now over 18, and she's got the only one. It's a given there's going to be a modification. I think the hang up is she doesn't want to acknowledge she's been paid more than.
I'm going to stop you there. I don't know what she's going to say or not say on the substance. I'm just trying to figure out if I want to go forward, if I should make y'all go forward today or not. And, how long is your meeting lasting for?
About 2 hours.
We have not a huge docket today, but I don't really want to be around for just your case at 3 o'clock in the afternoon or whatever, maybe 2 o'clock maybe. Okay, I get it. So, Ms. Coates, any more questions for Mr. Purser?
No.
Then if you want to call Ms. Tanavskaya.
Ms. Tanavskaya, can you hear me?
Yes, ma'am, I do.
Okay. I understand you don't want to reset this. Is that correct?
Yes, ma'am. May I explain, please? May I explain?
Explain why you don't want to reset this?
Yes.
Yes.
Yes. Can I speak?
Yes. Why do you think we should not reset this?
Because Buford Purser had 2.5 months since July 11.
He's had too many what? He's had
Buford Purser, he had 2.5 months since July 11 to provide me those receipts. He didn't provide me the receipts. He didn't provide her the receipts. I know he changed his residency, the address. He changed his employment. He didn't notify me as court order about his new address or his new employment.
Ms. Tanavskaya flatly rejects a reset and presses for immediate action. She says 2.5 months passed without receipts and payments stopped on August 25th. Her testimony is charged and personal. She frames this as survival, not paperwork, stressing that delayed enforcement affects daily life and the child's welfare. The judge listens closely as frustration and real-world need color every question about timing and fairness.
He did notify, I wonder, did he notify court with his new address and new employment? Did he? Because this court order. He doesn't like to follow the divorce decree, the order.
So you're okay. So the issue is not that we don't have the documents today. We have it today. It's just that he's not available because he has a meeting that's going to start soon and will take 2 hours. Is coming back in November an issue?
Oh, he knew about today. He should have made arrangement already with the work and with everything. He knew how important it is. Because from July 11, it's 2.5 months. He had plenty of time to prepare it. He doesn't want it. I requested child support in February 2024, almost 2 years it will be. So one year and 8 months I've been patiently waiting. He stopped making any current child support payment since August 25th. So 33 days he is behind on his child support. Did he notify the court? Why did he stop making child support payment? Why?
Is there a court order for child support, Ms. Coates? I assume there is.
Yes.
It's direct pay credits, right?
Yes, Your Honor. That's
No,
the
what?
issue.
The issue is not that what he's not doing now, it's what he might be entitled to credit for in the past. So
Yeah,
that's not the hearing
Yeah.
you want to have, ma'am, why he's not paying now, even if I went forward today. This is about what is it? How many years since 2019?
Yeah.
6 years of payments that I'm going to have to look at 77 pages and you can't see it. Is there some reason you can't log on into the Zoom app and so we can have you present and being able to view documents? Is there some reason you're not on Zoom?
No, I can't. My phone is very old and it's maxed up all the members. It kicks me off. I can't use it. But I have divorce decree which he signed up and he agreed to.
With paperwork mounting, the judge steers the case toward in-person proceedings. The state concurs that Zoom can't handle an evidentiary fight of this scale. Clerks and counsel discuss courtrooms, Friday dockets, and which dates can accommodate a lengthy review of financial records. The tone tightens. An in-person hearing will force transparency, allow document exchange, and ensure parties can meaningfully challenge evidence in real time. Delay is no longer a neutral option.
And on the page 25 of divorce decree, it
No,
says,
we're not talking
Thank
about
you.
that right now, Ms. Tonovitskaya. I know you want to prove your case, but I'm just trying to do the logistics on whether it's feasible to do a hearing today, right now, under these circumstances or not. So that's what I need to address. Do you live in Comal County?
yes, ma'am, I'm in a Comal County.
Mr. Purser, are you in Comal County?
Yes, ma'am.
Because, not everything is meant for the computer. And today on the phone, especially Ms. Tonovitskaya, I'm going to have to do a lot more work to make sure you know what's being shared on the screen that you cannot see. So I have to talk about everything on it and what it says and what it is, and you can't see it for yourself. Now, has Ms. Tonovitskaya been given copies yet of any of the documentation, Mr. Purser, or just the state?
Just the state, ma'am.
Honestly, I don't even think this is appropriate for Zoom. With that much documentation, I would love that we go to a courtroom, everybody has copies ahead of time, and you get to review them before you come in front of me, and then I have a stack too or whatever, because it's so difficult with numerous volume of pages to do that on screen share. It just really is, and it could take hours to do that when it wouldn't be so hard if we had paperwork ahead of time and we're able to prepare a little bit better than just sharing for the first time on screen share and either the state or me talking about every single thing on a page that we're looking at. So I'm going to propose that unless I hear something else, Ms. Coates, did you finish your cross-examination of Ms. Tonovitskaya? Let me let you finish.
Yes, Your Honor. Yeah, we're done, and the state agrees. It's probably best if this is an in-person case.
Yeah, that's where I'm headed, where I still have the ability to ask for a courtroom, be assigned a courtroom, and go there in person and have you all there, either a whole docket of in-persons or just one case in person with the rest of them on Zoom, because this is not a Zoom platform case. And because you don't have lawyers, I hesitate to hand you over to the district court and y'all go over there in front of a district judge on your own. I usually send the cases that have lawyers to another court that's already sitting there.
The focus turns to relief. The mother asks for a temporary child support modification and cites an agreed figure she expects to enforce quickly. The judge clarifies that any modification can be dated back to service or appearance, meaning eligible relief isn't forfeited by waiting for a full hearing. That legal reassurance matters. A procedural delay won't erase entitlement, but it does shift how the financial ledger will be reconstructed at trial.
But for me, it would require getting a court date in a courtroom in Comal in the near future, which I think is doable. So yeah, I'm gonna set this for in person. The question is, which Friday docket do we try to use for that? The state might be able to help me with that in terms of numbers or how many are already on Zoom that we have to hear on top of a one in-person case.
And excuse me, I have a question, Mayor.
Yes, ma'am.
I'd like to inquire the temporary order to modify child support because it's been for too long for me waiting. I remember the attorney, she says that we agreed on the same amount, $1,526.
Well, I'm trying to get to the courtroom in the next few weeks. I'm not talking about 2 or 3 months, ma'am, or next year. I'm not trying to do that. So I can hear it all at once instead of splitting it up. It would just be easier to do it that way.
But it is a separate issue, and I really do need child support. He stopped paying child support.
Is there a child? I already understood there's a child support order, ma'am. So you're entitled to child support until it stops. And if you're entitled to, if you filed a modification to Ms. Coates and they've been served with it or appeared on it, correct?
Yes, Your Honor. This is like I said, a modification and.
Okay. So what would happen with that, Ms. Tonovitskaya, if you're entitled for me to order more child support or him less child support, I can date it back to when you all were served or appeared in this case. The law says I can go back, so you're not going to lose out if I hear it a little bit later and I don't hear it today. So I'm trying to see if let me see if we're still on the Zoom here. My coordinator can call the courthouse and see if they can get us an assignment. I don't know.
I can get you a room, Judge. Just tell me what date.
Yeah.
November 14th only has 4 cases right now.
November 14th? 4 cases? Oh, that would be ideal.
FYI, the day before we're in Hayes person.
Yeah, I know. There had to be travel day, 2 days back to back. How many cases are? What's October 24th? I already have a priority on Zoom.
Calendars and real life collide as the bench and parties negotiate dates. Mr. Pusser explains new job constraints while the mother pleads about living without timely support. She presses for the father's current address to enforce orders. He resists providing it on Zoom, citing privacy, and non-disclosure concerns surface. The judge balances safety and enforcement, noting contested disclosure issues will be resolved at the in-person hearing, where evidence and context can be fully examined.
What about November 7th? Ms. Coates, do you have any idea how many cases are on that docket?
11, and then we just added one more, so that makes it 12 cases.
What about before that, right? This today, okay, in about a few weeks on the 17th, we have 10. Is that right? No priorities that I know of.
I don't know how many cases are set for October 17th. Let me ask.
Let me ask my coordinator on your management system. Do you know how many cases, Ms. Gonzalez? I have 10, but I'm not sure if my numbers are the most.
I have 12.
12? Okay. Well, you know what? I think I would rather do the 4th, even if it means back-to-back travel, because that's the tiniest docket we have. In this case, is going to take a bunch of time. If we're talking about 6 years of payments and a lot of documentation. So, sir, are you available on Friday, November 14th?
Yes, ma'am.
And you're not going to make any conflicting appointments?
No.
Okay.
Part of the problem was it is a new job, and I just didn't have the flexibility I would have had a few months ago.
Okay, because it is a priority, and court
Agreed.
would be a priority, especially if it's reset for this very reason. I don't know if we can get a courtroom that day, but we can try. So for right now, let's say November 14th at 8:30 in Comal County in person. Ma'am, do you have any conflicts at all on Friday, November 14th?
It's for what, 1 month, over 1.5 months. How I can survive without child support? How I can get child support? And what's his new address? Could you please ask him? Because he's picking up child every week. I do need to know father's new address, new residence.
May I answer, ma'am?
Yes, without giving an address on Zoom. I mean,
Yeah, and I do not want to give an address. The only delinquency I have is for the month of September because I no longer have it automatically withdrawn. I had offered to pay that to Yana in cash if she just acknowledged it with a receipt, because I can go through your app, but it's delayed. She won't get it for about 8 days. I knew we were going to be in court and we just addressed it at that point. I wasn't sure how this was going to work out. I have no problem paying September's.
A seemingly procedural exchange proves pivotal. Mr. Pusser admits a registry delay of roughly 8 days between payment and distribution and offers to hand-deliver September's support if the mother acknowledges receipt. The judge stresses traceability and prefers registry payments to ensure credits are clear and enforceable. How payments are routed will shape credited amounts, arrears calculations, and the evidentiary fight over past transfers. This matters.
there's a delay of 8 days on your distribution thing.
I'm sorry, ma'am.
No, I'm asking Ms. Coates. You're saying the state's registry for payments is taking 8 days to get to money to get to the other parent? Usually it doesn't take that long. Is there? I know you have a new system, Ms. Coates. Are you aware of any problems with distributions? I'm sorry, I'm picking.
It's a case by case situation, but yes, sometimes there is delayed, but not like a big delayment.
Yeah. Well, geez, if the issue is you shouldn't get credit for payments outside court, I don't really want to set up another payment outside court.
I believe, yes, it's best that he just pay through the system and she just has to wait.
So, Mr. Purser, I can't hear you. It looks like you're talking, but you're not muted. But I can't hear you. What, sir?
He may be starting his meeting soon. I don't know.
Well, it's 11:08. Yeah, I'm going to set it for that November 14th court date at 8:30. Mr. Purser, go ahead and make your payment and make it through the system. The sooner you make it, the 8 days will go by quicker, and hopefully there won't be that problem. But I don't know what else to tell you. If she's entitled to child support and you're delinquent, you need to pay, obviously. So that's the best I can do. Now, is it true you haven't provided a current updated address to her?
Yes, but with cause. I'm not allowed to. I pick up my son once a week for 2 hours. We don't even go to my house.
Okay,
So-
then I'm gonna deal with that issue. If there's a non-disclosure issue of some kind, I'll deal with
There
it
is.
on a court date. So I can't hear it right now in 2 seconds because I'm gonna have to let Mr. Purser go. So y'all are on notice unless you hear otherwise or get a document otherwise that we're gonna attempt to get the November 14th date. And
Judge.
yes, ma'am.
I've already sent an email requesting a courtroom for that day.
Okay, wonderful. So we should know fairly quickly. Mr. Purser, do you want to leave and maybe we'll check back in? Well,
That's fine, ma'am.
you may not
We-
be here by the time.
We have their
I have a
information, Your
question.
Honor.
You have what?
I was saying we can call the parties and let them know.
Okay. Then Ms. Tanaskaya and Mr. Purser, I'm gonna let you go. Right now, the court date is November 14th at 8:30 in person in Comal. And if it change, well, you're gonna get it in writing anyway. If that's a good date, we'll find out fairly quickly. And if they change,
I
it,
have a
they'll let you-
question. Last question. It is court order that he has differently person has to provide me with his new address. It is in a divorce decree. I want to know his new address.
I addressed that already. There's some non-disclosure issues. Now it's contested. I need to hear it. I need to hear all of it, not just your request for it under a prior order. I have to hear the current circumstances and see whether I can allow it or not anymore. So I'm going to defer that to the actual hearing on November 14th as well, ma'am. So I can't hear it right now in 2 minutes. So, okay, I'm going to excuse you all. I'll see you November 14th at 8:30, or you will know otherwise if the state contacts you or you get a court order that has a different date on it. Please pay attention. But it's going to be an in-person case. So
Yes, ma'am.
expect to go on November 14th unless you hear otherwise. Thank you. You're both excused at this time.
The judge concludes with a firm procedural order. An in-person hearing is set for November 14th at 8:30, and the father is urged to make payments through the official registry to ensure traceable distributions. Contested non-disclosure and address questions are deferred for the full hearing so evidence can be weighed in person. Prepare exhibits, document transfers, and like and subscribe to the channel, and we'll see you in the next video.